Hello and welcome to my channel SPARX STENOGRAPHER. Today I am going to deliver your legal dictation. Exercise number 55, words 498, speed 100 words per minute. So guys, ready for the dictation. 10 second, 5 second, start. Shri Ramanand Pandey, the learned additional chief standing counsel, while opposing the said submissions advanced by Shri Bhanot, has contended that the 1985 rules and more particularly Rule 1 thereof clearly prescribed that they were to come into force at once. Shri Pandey consequently submits that the 1985 rules would be deemed to have come into force on 16 March 1985 itself. According to him, merely because these rules dated 16th March 1985 came to the published in the Gazette only on 31st August 1985. This would not have the effect of postponing the date when the rules would be deemed to have come into force. According to Shri Pandey, the use of the words that once in Rule 1 unambiguously establishes the legislative intent of the rules being made enforceable from the date of their making and would therefore be deemed to have come into force on 16 March 1985 itself. Consequently, he submitted that no appointment post 16 March 1985 would have been made without following the procedure prescribed. Before we deal with the primary issues convinced before us, it becomes apposite to note that the order of termination did not rest upon this issue alone. Admittedly, the government order dated 31st October 1984 clearly held the field at the time when the appointment of the appellant came to be made on 18 April 1985. This government order clearly prescribed the year of recruitment of commence from 1 July and to the end of 30 July of the following year. We further note that the government order dated 31 October 1884 referred to the subordinate officers, clerical staff, direct recruitment, Fourth Amendment rules 19796, which appear to have governed the field till they were suspended in their operation by the government order dated 31 October 1984. The suspension of these statutory rules appears to have continued till the promulgation of the 1985 rules. During the interim, the provisions of the government order dated 31st October 1984 appears to have occupied the field and governed the subject of selection to post in the subordinate offices in the state of UP. This government order prescribed the composition of the district selection commission and the procedure to be followed by the said selection committee while affecting appointments to posts in the subordinate offices of the state. Admittedly, the appointment of the appellant came to be made on 18 April 1985 prior to the commencement of the year of recruitment as prescribed under these rules. We note that the learned counsel for the appellant was unable to establish before us that this objection noted in the Government order dated 23 September 1985 was either unjustified or unsustainable. In our considered view, this objection noticed in the impugned order dated 23 September 1985 was sufficient to sustain the termination of the temporary engagement of the appellant. However, since much argument was advanced on the issue of commencement of the 1985 rules, we proceed to deal with the contention also thereafter. Stop.